Okay, I'll just deal with in a moment. I'll invite Mr. Rowan Richards from the Ministry of National Security to open today's seminar on the subject of UOs and similar tools, which are going to be given by Anita Clifford. Before I do that, if I can just deal with a couple of admin bits, just to welcome a couple of guests who I see with us. Caroline Hay, QC, welcome this afternoon, Caroline. I see Professor Monroe is with us, and thank you, Professor Monroe. I know you've spoken on this subject, and I'm great to see you here and your interest. And also Keith Darien, who's the acting Chief Technical Director of the FID. So it's lovely to see you amongst many others, and it's great to see many friends in here as well. If I can just very, very quickly deal with a couple of admin or housekeeping matters before we start. In terms of questions, I've put something in the chat, but basically, I don't want to interrupt Anita's flow. I think it's far better if we deal with questions at the end. So you can either put questions in the chat and we'll deal with them between myself and Anita, or I'll invite oral questions and we'll unmute at the end of the session. And with that in mind, can you obviously all keep an eye on your microphones and ensure, much as it's lovely to hear you ordering a cup of tea from somebody in your house, we probably don't all need to hear it. So, but without further ado, I'll invite Mr. Rowan Richards, Chief Technical Director for the Ministry of National Security, who've got responsibility for the implementation of changes to the POCA legislation and policy, etc. Rowan, we're in partnership with you on this, and I just invite you to open this seminar. Thank you.
Okay, thank you very much, Alan. Let me just say thank you to everybody for turning up on this very rainy Sunday afternoon. It just goes to show we have 45 persons in this meeting, which goes to show exactly how important this topic is. So just again, to reiterate, my name is Rowan Richards. I am the Chief Technical Director in the Ministry of National Security with responsibility for law enforcement, and under that portfolio is the whole issue of the proceeds of crime and financial crime matters. Now, since 2018, 2019, we have been working with the FID to see how it is that we could introduce unexplained wealth orders as part of our asset recovery framework. We made an attempt when we last amended our POCA legislation, but we realized that we needed a lot more work to be done, a lot more research to be done to ensure that it will stand up the test of constitutionality. Given the role, of course, of FID in asset recovery, we have been in constant dialogue with the division, amongst other stakeholders, regarding how it is that we could integrate the UWO into our POCA framework. And I dare say that we are now at a juncture where it is no longer a if, but it's a must that we have to implement this or integrate this within our framework. So as part of these ongoing discussions between the MNS and FID, we thought it important to just have this discussion, invite an expert, and we want to again thank Anita for coming out with us this afternoon. She's a practicing UK barrister. I won't say much more because I'm sure that FID will have more to say about her in terms of how it is that the UK have been dealing with UWOs. Ms. Clifford is quite experienced asset recovery barrister, but is also a joint author of a key text on the Criminal Finances Act 2017 that saw the UWOs being introduced into the UK. And we were very heartened when we saw that there were some successes in respect of that legislation a couple years ago. So once again, just to say that as part of these ongoing discussions between the ministry and stakeholders in relation to the introduction of UWOs, it really is intended to contribute to this ongoing dialogue taking place with respect to the introduction of UWOs within our framework. So I will now hand over to Alan, who will introduce Anita, and hopefully we will have a lot more to learn this afternoon. Thank you.
Thank you very much, Rowan. As I say, that with the FID, we've been working very closely in partnership with Ministry of National Security just to look at all of these options. So, but anyhow, much as it saddens me to realise that you haven't all come here to listen to me this afternoon, what I must do is get on and introduce our guest speaker. And if you'll excuse me, I will read this so that I do Anita full credit. Originally from Australia, Anita qualified after a year as a Judge's Associate in the Supreme Court of Queensland. She was a solicitor from 2011 in private and government practice, with her early years spent at a prominent criminal and human rights firm defending vulnerable clients and gaining exposure to death in custody inquest. Subsequently, Anita came to the UK and was called to the bar in the UK in 2017. Anita is ranked in the Legal 500 and Chambers, and Chambers and Partners for Proceeds of Crime Act 2002 and asset forfeiture work, where she's described as a fantastic rising star who is knowledgeable and reassuring in the delivery of advice. Anita defends and prosecutes across a range of practice areas and has experience in civil proceeds of crimes matters. Alongside a general crime practice, Anita has a strong financial crime interest and advises on anti-money laundering investigations and regulatory requirements, suspicious activity reporting and account freezing. She also advises on the United Kingdom's financial sanctions regime. Anita is registered as a Part 2 legal practitioner in the Dubai International Financial Centre Court, where she's part of a legal team behind a significant claim in that court. Instructed by the Court of Europe, she's undertaken anti-money laundering and anti-corruption projects in Georgia, Moldova, Czech Republic and Serbia. She's also contributed to anti-corruption workshops in Kenya and Zambia in conjunction with the African Union. Anita is a contributor to the Lloyd's Law reports on financial crime, and as Rowan also mentioned, is co-author with Jonathan Fisher QC on the definitive textbook on the Criminal Finance Act 2017, which saw the introduction of unexplained wealth orders and similar investigatory tools. If that wasn't enough, in addition, she's been appointed to the legal advisory panel of a non-governmental organisation, the Global Legal Action Network. Anita, unfortunately, you're not here with us physically, but spiritually, you're with us here in Jamaica. And thank you very, very much, and we look forward to your presentation.
Thank you very much indeed, Alan, and thank you, Rowan, both of you, for that very kind introduction. I have called this afternoon's presentation Unexplained Wealth Orders, Game Changer or Paper Tiger. I am very interested in financial crime law reform, as you can probably gather. I'm originally from Australia, which was one of the pioneer jurisdictions of unexplained wealth orders, and in the last 4 years have had some dealings with unexplained wealth orders, advising on them, also commenting on them. And what has been particularly interesting really in the last 2 years is how that unexplained wealth order experience has unfolded in the UK. And it must be said, perhaps things have taken a little bit of a turn in practice. So therefore, there's a lot of discussion at the moment in the UK as to whether unexplained wealth orders or UWOs really are the sort of big game changer that one thought it was to be. So that's the topic we're going to discuss this afternoon. I'll just click through to this overview slide. We will be going through in detail as to what an unexplained wealth order is, insofar as it's in force in the UK, what the context was to UWOs being introduced into the UK. We will look briefly at similar provisions in other jurisdictions, including in Australia. And then I will talk about some of the recent case law in this area as well. When we'll finish with certainly look at some other provisions which are introduced as part of the Criminal Finances Act as a suite of investigative powers alongside the unexplained wealth order regime. So that's where we're going today, and I would very much welcome your thoughts and discussion at the end of the session. So if we might orientate ourselves, as Alan has mentioned, the Unexplained Wealth Order regime was introduced as part of the Criminal Finances Act 2017. That really was landmark legislation in terms of amending our Proceeds of Crime Act, which I understand is very similar in lots of ways to the Proceeds of Crime Act that you've got in Jamaica. There have been very few amending pieces of legislation of scale since POCA was introduced in 2002. And the Criminal Finances Act in 2017 really was the main piece to amend it in all that time. Part 8 is where you will find the Unexplained Wealth Order. Its provisions came into force in January of 2018. And the mood music at the time when it was introduced was very much about wanting to bolster law enforcement and respond in particular to the problem of grand corruption. And in this respect, it might be somewhat different to the rationale to introducing UWOs there in Jamaica. Certainly the impetus in the UK was great concern about grand scale corruption and the proceeds of that corruption often sitting in places like London, Manchester, Edinburgh, where kleptocrats are hiding their wealth on these shores, and the Proceeds of Crime Act not being fit for purpose in terms of doing much about it. And so that was really the discussion around the Unexplained Wealth Orders before they were introduced. Here I've just put together some quotes from the discussion as around UWOs before they were introduced and just after. Certainly there has been growing concern about money laundering in the UK, particularly in London. There is concern that it's very difficult to investigate because people who are laundering their funds through London in particular are highly sophisticated. They're often using the very best law firms, the very best financial advisors, and it is very difficult to get to the bottom of what the criminality is in the first place, let alone trying to target their assets. And this was sort of ongoing discussion really right the way back from 2015, 2016 under Prime Minister David Cameron at the London Corruption Summit. And there was great sort of calls to do more. And that's why there was a suite of investigative orders which were really packaged together in the Criminal Finances Act, one of which is the Unexplained Wealth Order. Now, it's right to say that that was the initiative that gained the most attention, and indeed still does. If we look at some of the discussion right the way back from 2015, you had lots of tough talk, starting right from the top with the Prime Minister saying that London is not a place to stash your dodgy cash. Here we are, we've got unexplained wealth orders. This is a positive statement from law enforcement that they are going to send a clear message to those seeking to launder their corrupt wealth through the UK, that that's no longer tolerated. You had successor Prime Minister to David Cameron, Theresa May, in her address to the United Nations, directly reference unexplained wealth orders, and particularly the deterrent effect that she anticipated that would have. All of that was very much designed to, I would say, be seen to be doing something about the enormous amount of illicit wealth which is in the UK. And indeed, just in the last 3 weeks, unexplained wealth orders do remain in the headlines, even though in practice, the case law in that area has basically come to a halt. The reasons for that we will get onto in this talk. But even notwithstanding that, you have our current Home Secretary making direct reference to unexplained wealth orders in relation to wanting to tackle illicit Russian wealth here in the UK. And so it's still very much front and centre of the dirty finance strategy here in the UK. And that has been the case for a number of years now. Why new powers? And this no doubt reflects some of the discussions that you here in Jamaica are having at the moment. But in terms of the jurisdictions that have introduced unexplained wealth orders, or indeed are thinking about doing so, and there are a number that are, I do quite a bit of work in Eastern Europe and have had very similar discussions with counterparts there who are working in law reform and who are very interested in bringing in unexplained wealth orders or something similar. And the reason for that really tends to be because of the difficulties that exist in trying to pursue criminal prosecution. I know a number of you, of course, are from law enforcement, and so you will know that it's very difficult, particularly where sophisticated money launderers are involved, to pinpoint what the underlying criminal activity is, or even to pinpoint to the criminal standard, their connection with that criminal activity. In particular, and this is something which is also a big issue here in the UK, is that money laundering, corruption, organised crime is so international that trying to build a case quite often involves mutual legal assistance requests, obtaining information from overseas. Jurisdictions might be prohibited or restricted even if they want to help, and it's difficult to build a case against those who are at the top. Further, of course, it is attractive to pursue civil proceedings or civil recovery proceedings rather than post-conviction confiscation proceedings for a variety of reasons. Firstly, you can pursue those proceedings, of course, if the person is not in the jurisdiction, or indeed if they are deceased. Further, the standards of evidence admissibility are, of course, lower. And that has its main attraction in why civil recovery and more powers to bolster civil recovery really are being pursued. And I should say, since the UWOs were introduced in the UK, there has been even more talk and push towards using civil recovery powers more and more here. So then looking at the inspiration, as I say, you had discussion of UWOs here in the UK right the way back from 2015 onwards. You then had Transparency International throw their weight behind UWOs in a big way, and they were remarkably effective in lobbying for UWOs to be part of the Criminal Finances Act. The inspiration for that regime and the provisions that ultimately came into force in 2018 is drawn from two jurisdictions in particular, Ireland and Australia, which is where I originally practiced. Both of those jurisdictions have had UWOs for a number of years. Australia in particular, I would say over a decade ago, they introduced UWOs. In Ireland, it's not called an unexplained wealth order, it's called something else. But the focus and what it does is very similar to what we know as an unexplained wealth order. The term's not used, but in short, it is an order requiring a person to explain the provenance of a particular asset. In Australia, the term is used, and they are enforced in a variety of different ways, particularly at the national level. The Commonwealth Government most recently has only improved their unexplained wealth order provisions. At the state level, Australia operates a federalist system. I think all of the states in Australia have unexplained wealth orders on their statute books and have done so for 10 to 15 years now. Whether or not they're used in a big way is another question, because certainly in a number of states they are used very rarely indeed. mainly due to the cost of the proceedings. There is also quite a lot of criticism of reverse burdens, which are front and centre of the Unexplained Wealth Order regime. But that said, there are certain states, such as Western Australia, that have had very good successes with unexplained wealth orders and do continue to use them as well. Similar provisions also exist in Colombia as a way of tackling grand corruption there. And so these really were the inspiration behind the UWOs that were then lobbied for in the UK in 2015 and 2016. So in a nutshell, what are unexplained wealth orders? Now, it sounds like your discussion in Jamaica is at a very advanced stage, so I'm probably telling you what you already know. But insofar as they are in force in the UK, you will find them in Part 8 of the Proceeds of Crime Act. It is an order which requires an individual, so the respondent, to set out the nature and extent of their interest in property, to explain how they obtain that property. And that order is available in cases where there is a disconnect between that respondent's income and that particular property. Their whole purpose is to assist in the investigation of wealth. So the idea being that where very little is known about the provenance of that property, but there are concerns about it having an illicit source, that the Unexplained Wealth Order operates as an investigative tool. Of itself, it is not civil recovery proceedings. It is rather a precursor to civil recovery proceedings, if indeed you get that far. But it is more akin to another type of investigative order alongside a disclosure order or a production order or other form of investigative order, which you might use at an early stage of a proceeds of crime investigation. Now, I've already mentioned this, but it was originally introduced, although it can also be directed at targeting those suspected of serious criminality. But at least in the UK, the emphasis is very much on using UWOs to tackle grand corruption, to tackle kleptocrats and their wealth here in the UK. That is different, it must be said, to what the provisions do in Australia and also Ireland. The focus, and I can speak from my own experience in Australia when I was advising the police on this there, the focus in Australia when it comes to unexplained wealth orders is about serious criminality rather than grand corruption or kleptocrats or what we see here in the UK. It is rather looking at, I guess, identifying or requiring more information about wealth which is suspected to be the proceeds of crime, proceeds of organised crime, and it's very much directed at that rather than more high-flying, politically exposed persons. Now here in the UK, there was a discussion around 2015, 2016, when one was looking at, well, what do we do to do more to tackle dirty money here in the UK? And one of the proposals at that time was also a illicit enrichment offence. Now that is a criminal offence. A number of different countries have that offence, particularly those where corruption is rampant, particularly certain countries in Eastern Europe, parts of Latin America, but a criminal offence where, in essence, it makes it a criminal offence for a person to not be able to explain why there is a disconnect between their lawful income and this particular property. So you can immediately see parallels with the Unexplained Wealth Order regime because they're both targeting the same thing, a discrepancy in an individual's wealth. and a particular asset, but one does it with the teeth of the criminal law behind it, whereas the other, the UWO, is entirely civil. The illicit enrichment offence is a recommendation of the UN Corruption Convention. But it must be said that there have been a number of concerns about that offence, particularly in countries where it has been introduced onto the statute books, but there are concerns about fair trial rights, self-incrimination privilege, and constitutional challenges. And in a country like England and Wales, but also Scotland and Northern Ireland, there were real concerns about introducing a new criminal offence, which effectively removes in a fundamental way the right to silence by requiring a person to explain themselves. So for those reasons, there was a lot of support for the UWO rather than a criminal offence of illicit enrichment. And that's what ultimately was recommended. So then turning to what the effect of a UWO is, it is a High Court order. It ultimately compels the respondent to explain how they acquired that particular property, what funds they used, and he or she must do that with a set time frame. A company can also be the subject of a UWO as well, and so they might that also applies to them. It is all about evidence gathering, because what is contemplated is that law enforcement would look at the information that is provided, and if they found that it was insufficient, then ultimately civil recovery proceedings would commence under Part 5 of our Proceeds of Crime Act. Potentially also, although the information which is provided by the respondent can't be used against him or her, or it if it's a company, in relation to a criminal investigation, it can certainly be used for leads in potential criminal proceedings down the line. And it can also be used to target other people around that respondent. Front and center of the UWO regime, as you would probably already know this, is the reversal of onus, which in places like the UK, when the legislation was being discussed, that did raise a number of concerns that there was this reverse onus that was being foreshadowed. But it must be said that although you can expect criticism of that kind, certainly in the UK and also in the European Court of Human Rights, it has been considered proportionate to have reverse onus provisions, particularly where illicit finance concerns are at stake. The touchstone, though, to ensuring that those sorts of provisions are seen as compatible with human rights or constitutionality is that there must be fair trial rights, rights to be heard, rights to be represented, rights of appeal, and all of that needs to be properly considered if a UWO regime is going to be not just introduced onto the statute books, but to withstand any challenge down the line. Now, this is just as a further slide on the human rights considerations. There is a case if one is looking at reverse onus provisions, but the Georgian case in particular does talk about the compatibility of the reverse onus with European Convention rights. And in particular, the things that will, I suppose, safeguard UWO provisions from attack in the courts is the fact that there is a fair balance which is struck between requiring a person to provide information, which is a very intrusive measure, but there is a fair balance between that and that person's rights. So things like fair hearings, appeal processes, as I say, representation, right to the information relied upon in support of the application, rights of appeal, not making the burden on the respondent too excessive in terms of expecting the information that he or she would provide. All of that will need to be properly taken into account. Now, looking at the UK legislation, there is a definition of a UWO in the Proceeds of Crime Act. It sets it out as a UWO. It requires a person to provide a statement, which, not just in our layman's terms, requires them to explain the provenance of an asset, but they must set out the nature of their interest in that property and the extent of that interest. They must explain how they obtain the property, including any costs incurred in doing so. If the property is held within a trust, then full details of that trust must be provided. Additionally, the law enforcement agency applying for a UWO can also seek that the order contain certain specific information that needs to be provided as well. The statement itself can be done in written form, or the order can require the respondent to provide, and the few cases that we have had in the UK, this has been done, has required the respondent to provide a video statement explaining their acquisition of various property. Additionally, the order can require them to deliver up specific documents as well. And I've seen that take place as well here. A number of applicants here in the UK can apply for a UWO. It must be said that the only applicant so far is the National Crime Agency, which is our lead agency when it comes to matters of money laundering and sort of grand corruption and organised crime. But our Revenue, the Financial Conduct Authority, the Serious Fraud Office, and also the Crown Prosecution Service, the DPP, they are all applicants as well with this power to apply. The order itself can be made on an ex parte application, and the few orders that we've had have all proceeded that way. Property must be specified. These are not orders, it must be said, which, even if you have the gravest suspicions about an individual, these are not free-ranging orders. They are very specific in that it will apply to that respondent in relation to very particular property. So, for instance, even if a person who is the respondent has a number of properties, for example, here in London, it will only apply to the one or two that are actually specified. Additionally, the interim freezing order, or an IFO, will ordinarily attach to an unexplained wealth order. It is a separate application, but it will typically be part of the same order, and it will freeze the property which is specified in that order, where the court is satisfied that there is a real risk of dissipation. Now, as for scope, and this is quite interesting, it's not at all out of line with our Proceeds of Crime Act, because of course property outside of the UK can be captured, and that is also the case when it comes to a UWO and asking a person to explain particular property. And it can also capture persons who are outside of the UK. It is, though. So far we've had 9 different UWOs, but only in relation to 4 cases in the UK. And we will step through those cases in a little bit. But so far, all of the UWOs have only related to property that is in the UK. Although the UWO provisions do contemplate it relating to property outside of the UK, for instance, this would have to be the subject of enforcement assistance. There are provisions for that, but it's not known just how willing other jurisdictions will be to accede to such a request. And so far, all of the UWOs have just related to property which is domestic in nature. There is very clear statutory criteria for the making of a UWO here in the UK, and I'll talk you through that. But basically, there is a financial threshold which must be met. It is very low, but the property which is specified must be greater than £50,000. There must be reasonable cause to believe that that property is held by the respondent. So that's the first condition, if you like. Secondly, the High Court judge must be satisfied that there are reasonable grounds for suspecting, so a very low threshold there of suspicion, but suspecting that the known sources of income are insufficient to enable that respondent to afford the property, or where there are reasonable grounds for suspecting that the property has been obtained through some kind of unlawful conduct. Now, I'm just pausing there because that is actually a very new addition to our UWO framework, which has only come in the last 4 weeks. Previously, the UWO framework was only activated if there was this disconnect between a person's income and that particular asset, but it has been widened in response to events in Ukraine to include reasonable grounds for suspecting that that property has been obtained through unlawful conduct. Thirdly, there is no public interest consideration. Unlike some other regimes, for instance, a number of the Australian jurisdictions do contain a public interest consideration. But ultimately, this is a discretionary order. The language is very much about retaining discretion. And so even if these conditions are met, a High Court judge could refuse to grant the order. Now, looking then at the respondents to this order, now this is very particular again. Here in the UK, because the context was really all about wanting to take action against corruption, one of the category of respondent who can be subject to a UWO is a politically exposed person. So a person who is outside of the UK and outside of the European Economic Area. What that means is that a lot of the CIS countries and PEPs from those countries have then been looked at for a UWO because of the emphasis on them rather than a EU or UK PEB. A second type of respondent is a person with reasonable grounds to suspect that he or she, wherever they are, is involved in serious crime. Or, and this again is one of our new provisions which have only been introduced in the last 3 to 4 weeks, or is a responsible officer that owns property. And so that is new. And the reason for that is there was a concern that there could be nominee directors There could be trustees and the like who are obscuring the owners of that particular property, but there are concerns about that property. And this provision was introduced to make it easier to get a UWO against company directors, even if they don't actually hold the beneficial ownership in that asset, but to get a UWO against them in order to acquire information about that property. Just come in the last 3 weeks. A PEP, there is no time limit here. So potentially any person who has been a PEP at any point is within sights of the UWO regime. The reason I say that is because the legislation refers to a person who is or has been entrusted with a public function by an international organisation or a state, or indeed who is a family member or an associate, a close associate of that person. So potentially if a person held high political office many, many years ago, but doesn't hold that office any longer, they could still meet the definition of a PEP for the purposes of a UWO. If a person is a foreign PEP, then there's no need at all to suspect that they are involved in any criminality. And that's because the foreign PEP status is reason of itself, the legislation says, to get a UWO against them, so long as the other condition of a disconnect between their income and property is satisfied, or there is grounds to suspect that that property has been obtained through unlawful conduct. The second type of respondent is a person who is suspected of being involved in serious crime. There is a whole schedule of offences which defines what serious crime is, but for our purposes, or a lot of UWOs or UWO investigations, the serious crime will be money laundering, tax evasion, and bribery, alongside the more conventional types of serious crime such as drug trafficking, firearms, etc. Indeed, tax evasion, given that the threshold is a low one of reasonable suspicion, when you're looking at something like a UWO, suspicion of a serious crime of tax evasion is likely to be easy to have, because you will already have, in many cases, suspicion that there is a disconnect between that person's lawful income and their property. And so that information can also potentially double as information to ground your suspicion of tax evasion. So it is quite an easy threshold on one view to meet. Additionally, not just the person who is a PEP or is a spouse of a PEP, or the person who is involved in serious crime, but also a person who is connected to a person involved in serious crime is also, they are also potentially within the sights of a UWO order. And that has a definition in our legislation which will refer to, unsurprisingly, spouses, close relatives and the like, but also individuals who are acting together in a company. So potentially not just foreign PEPs, but a rather wide pool of people could find themselves on the end of one of these orders. I've just put a slide here on who a PEP is, but I'm sure it will be familiar to all of you with the money laundering laws, who would fit the bill of a PEP. But in essence, the UWOs that we have seen in the UK, they haven't gone against any heads of state or heads of government or the like, but what they have gone against are PEPs who, or at least in the factual matrix, the respondent has been the spouse of a PEP, for instance, but the PEP status is because that person was high up in a state-controlled bank. So they're not necessarily going for people who have assumed high political office, but they're going for people who are drawn from business and who might be involved in some kind of state-owned institution. The reason, which I think is quite interesting, because when you look at why they've gone for some of these targets here in the UK, rather than those who hold high political office in foreign jurisdictions, the reason I think that, at least in the UK, we've not gone down that route is because potentially there are concerns about, well, how politically that would look like or play out, and also potentially concerns about how diplomatic immunity would work as well. These are all unanswered questions, I must say, but when you think that in the UK, the discussion around UWOs before they were introduced, that it was all about wanting to tackle grand corruption and people who launder their money through the UK, who might be highly corrupt ministers and the like from foreign jurisdictions. We haven't actually used these powers against people of that ilk, because I think there are a number of questions about how exactly that would work. Now, looking in a little more detail at what the disconnect between lawful income and property means, so that's one of the key criteria. The Act itself is silent on the evidence which is required to support the disconnect. But what we have seen in the cases that have been brought are references to, well, in one case, what was publicly available about that person's income because of reports that had been prepared by NGOs, and in particular corruption NGOs. Looking at other cases, perhaps in another case, a case of Hussein, which was directed not as a foreign PEP, but at a person suspected of involvement in serious criminality, then one is then looking at more conventional sources of proof of their lawful income, such as their tax returns and other information which is held by the revenue. Those are ways of trying to meet that criteria of disconnect between income and assets. One thing, though, about the UWO regime, which potentially makes it a bit difficult to go after some of these foreign PEPs, but there is a provision which says that income will be lawful if it is obtained lawfully under the laws of the country from where it arises. And so, look, on one view, even if there are grave concerns about that individual being involved in corruption, if ultimately in that jurisdiction it is seen that they have behaved entirely lawfully and that income is entirely lawful, then it is impossible really to get a UWO against them. So in one sense, whether a UWO is available will depend on the political factors in that jurisdiction. So a PEP, for instance, who has fallen out of favour with their government is going to be more vulnerable to a UWO than one who is still very much aligned with their government. Additionally, other ways of I guess, amassing the evidence to support the disconnect between asset and income, lots of open source material, things like asset registers, publicly available salary information, particularly if one's dealing with foreign pets or people who hold political office. There is a lot of information which is available on the internet and can be used, and mindful that it is a civil application, the same standards and requirements for evidence in criminal proceedings simply will not apply. Now, when is property held? So you will remember that one of the conditions is that the respondent holds property to the tune of £50,000 or more. What does that mean? So a very broad provision in our Proceeds of Crime Act as to when property is held. So where the respondent has effective control over the property, where they are a trustee and the property is held in that trust, or even where the respondent is a beneficiary in some way in relation to that trust, they will all be regarded as holding the property. Additionally, mindful of the recent reforms to the UWO framework in the last month or so, a person can be a responsible officer and can also hold property even if they are the director of a company which holds that property. They can also be a respondent as well. And it expressly sets out in the Proceeds of Crime Act 362H that a person who holds property can include any body corporate. Now, responding to a UWO, so if that statutory criteria, which I've just walked you through, is met, the High Court still retains the discretion not to order it, but there is no set public interest criteria. So in the few cases that we have seen, which have all proceeded ex parte, those orders were, insofar as we know, we don't know of any others that have been applied for but not granted. But those that we do know about, they have been granted, and they have been granted ex parte on the basis that that statutory criteria has been satisfied. What then kicks in, of course, is the time limit for then the respondent responding to the UWO once that UWO is served on them. It will set out how to do it, whether it must be in the form of a written statement or a video statement, whether other specific documents must be delivered up. But the information then, of course, must be provided by the respondent. And in terms of what has to be provided, I've just put the section here, but it is quite wide-ranging. So if there are any concerns about standard confidentiality, for instance, if one was a professional trustee, then there is a provision which sets out that the UWO has effect in spite of any restriction on the disclosure of information, however imposed. The only exception, which is not surprising, is that legal privilege is preserved. So one doesn't deliver up or provide any information which is legally privileged, but other than that, they have to provide all the information which is sought and all the information about that property. There is a response period which has to be abided by. And here we also have a code of practice which applies, and the National Crime Agency and other enforcement agencies ought to consider before they embark upon applying for a UWO. But here the code of practice refers to needing to be quite strict in the requests for information. The applicant, whether it's the NCA or somebody else, needs to consider, well, what precise information do they require, and categorise this in a structured fashion. This is in order to focus what the UWO is for, and to, as you can imagine, for law enforcement, not getting, you don't want to get a whole raft of information which is not ultimately relevant or doesn't assist. And so that is also something to bear in mind. Now, if a response is put together, here in the UK, that response to the UWO is provided to the enforcement authority for consideration, so to the NCA first, and not to the court. That is a point of difference between the UK and at least one or two of the Australian jurisdictions, where if a UWO is ordered, I think in at least one jurisdiction, the explanation for that property is provided directly to the court. Where that information is provided to the enforcement authority, it can be used in other proceedings. It can be copied. There's no provision at all as to how long it may be retained. And so you can see that it can potentially be very valuable indeed to investigations, not just in relation to that particular asset and civil recovery proceedings in relation to that asset, but potentially other targets sitting around the respondent. The information can't be used in criminal proceedings against that respondent, but can be used in other investigations as well. Potentially, and this is something we are also seeing, and I've been involved a little bit in advising, but where there is a UWO which has been served on a respondent, you can immediately see the concerns which might be raised by the professional people who have then, at one point or another, might have advised that respondent or been involved in that acquisition of property in some way. And potentially the UWO can open the door to civil, criminal, or professional regulatory investigations of the professional people who have assisted in some way. So a lot of information with a lot of value. Now, interim freezing orders. I mentioned this a little bit at the outset, but of course, because these are orders which are made quite often ex parte and are subsequently served on the respondent, at the same time, they will often contain interim freezing orders for that property. And so there are provisions about that in Part 8 as well. The test is really no different from other parts of POCA, but where it's considered necessary to do so for the purpose of avoiding risk of a recovery order being frustrated. There's no need for any good arguable case that property is recoverable though. So in that sense, because this UWO is very much an investigative order done at an early stage, the applicant enforcement authority doesn't need to then go that next step and in saying that, well, there is a good case for recovery, because you just don't know yet. The purpose is to get the information. So quite often the UWO, well, at least in all the cases we have had, have also had an interim freezing order attached. Now, I haven't put it on the slide, but I should have done. The UWO can also, well, contain provisions for the respondent to then go back and vary it or discharge it. But additionally, the UWO, and this hasn't happened, you don't have an example of it happening, but there are also provisions in POCA for the UWO potentially being subject to reasonable legal expenses to assist in challenging it as well. What happens then once the UWO is served? Well, certainly there are consequences for non-compliance. If there is no response which is provided, there's no criminal offence as such, but there is a recoverability presumption. Remembering that the purpose of a UWO is ultimately to act as a precursor to trying to recover the property in the first place. If there is no response and there is no reasonable excuse for no response, then it will be presumed that that asset will be recovered. What then happens if there is compliance? Well, certainly there are then provisions for, well, is that information accurate? That needs to be properly considered, needs to be verified. But if the explanation is provided and an interim freezing order is in force in relation to it, then there are time limits in play. An enforcement authority has 60 days to decide what it wishes to do. Query really whether 60 days is sufficient time, but at least within that 2-month period, they ought to know whether they're going to take that next step to commence Part 5 proceedings. If no action is taken, then the freezing order will be discharged, and that will be that. But there's nothing to prevent the enforcement authorities from changing their mind at a later stage. In terms of any criminal offences that do apply, as I say, not a criminal offence to not respond, but it is a criminal offence to respond to a UWO in a false or misleading way. This provision is completely untested, but it is on the statute books, and it does carry a term of 2 years imprisonment. Now, this is particularly interesting, and again, it's part of the new reforms to the Unexplained Wealth Order regime, which have just been introduced in March. And I'll just turn on the light here because it's getting dark here in London, so I'll just turn on the light. Yes. Hope that's a little bit better for you. But this will be big news, I think, and of great interest to those of you in law enforcement there in Jamaica. But there is a new clause 52 introduced of the Economic Crime Transparency and Enforcement Act of 2022, new 362U section of POCA, which says that costs cannot be ordered against the applicant enforcement authority where a UWO is ultimately discharged, or there is successful appeal, or perhaps it fails at first instance, unless the authority acted unreasonably in making the application, or they've acted dishonestly or improperly in some way. So that is going to be extremely valuable in future applications, because we will step through the authorities in a moment. But what has, in essence, ground the UWO applications to a halt here in the UK is because the last UWO, which was applied for, was at first instance granted, but was discharged on review. And the NCA got a £1.5 million cost bill as a result, which was a sizable proportion of their budget, as you can imagine, and then made, for obvious reasons, the NCA rather shy about pursuing further unexplained wealth orders. This new provision to do with costs, which effectively makes costs extremely difficult to obtain, will be a game changer. Now, key safeguards, just in summary. Certainly all those statutory requirements must be met for a UWO, which is an obvious point. The Part 8 of POCA contains the right to apply to vary it, to discharge it, rights of appeal. There are provisions, as I've already mentioned, to carve out reasonable legal expenses. I don't think in the few UWOs that we have had that there has been any reasonable legal expense application that has been required. That's because of those that we know about, the respondents have very deep pockets, and the UWO relates to particular property. It doesn't, and all of it so far has related to real property. So houses in central London worth millions of pounds, or estates, country estates, which are luxurious, but it hasn't related to funds sitting in a bank account. So there's not been the need to rely on any reasonable legal expenses provision. Other safeguards that we have here in the UK, so no right to require a person to answer any privileged question or produce any privileged material. There is an express provision which sets out that the statements that he or she makes can't be used against them in criminal proceedings. There is the code of practice that's not referred to in POCA, but it is a code of practice.
And I call, yeah. And somebody said to me, say,
yes, man. You want, man, if it, yeah, mean, say, you see, at least you feel the hole now. And that,
O'Neill, mute yourself. Thank you. Sorry about that, Anita.
No, not at all. Not at all. There is a code of practice which also applies. And this is, I think, it doesn't reflect any provision of POCA, but certainly the code of practice must be taken into account. But it expressly sets out that a UWO should only be sought where the information cannot be obtained via less intrusive means. And I have to say that in the last UWO case, where the NCA was ultimately not successful, that the idea that the information could potentially have been obtained other ways or should have been verified first before the application was made, that was all part and parcel of the judgment. So the NCA should not have simply leapt to getting a UWO. Proportionality must be considered. Finally, there is that discretionary point that it may be ordered. So that really is the package of safeguards for the respondent that we have here in our own UWO framework. And the reason I suppose we have that package is to temper what is ultimately a very intrusive investigative order, which does have a reverse burden. And so a number of these considerations are designed to, I guess, balance that out. Now, getting on to a little more of the case examples that we have had here in the UK. So this, I think, is quite interesting because it just shows that things haven't necessarily gone to plan. When the UWOs entered into force in January 2018, the year before, when the bill was going through Parliament, which I followed very closely, there was a government document which was circulated, which anticipated that there would be no UWOs in the first year that they were introduced, but thereafter there would be about 20 per year. So quite, I think, given it was a new a new type of order, one which was rather intrusive, but there was an expectation that it would be used in about 20 cases a year. What has happened is that since UWOs have been on the statute books, just 9 have been made, and it relates to just 4 cases. We've not had yet any successful civil recovery proceedings on the back of a UWO. Not to say that won't come, but it certainly hasn't happened just yet. In terms of the total value of property to do with those successful UWOs, it is rather eye-watering, £143 million. But those cases are still very much plodding through the court system. Just 3 cases have a published judgment, so this is not an area where there's any real body of case law just yet. And as I say, none at all since the end of 2019. Why is that? Well, part of the reason, and we will return to this when we look at the case in a little detail, is because when the NCA did ultimately lose its UWO in that most recent case, it did get a whopping bill, which then made it very difficult to pursue more. Those new reforms that we've just talked about, I expect, will build confidence in the enforcement authorities and will not necessarily mean a great uptick in UWOs, but I would expect that there will be more in the pipeline. Now, in summary, at one point, I should say, in 2019, it was disclosed that there were about 140 matters which were being looked at for UWO suitability. A lot of those were to do with foreign politically exposed persons, including from Russia. We've not seen, given that there have been only 4 cases, we've not seen really the fruits of those investigations just yet. And the reasons for that, apart from that one case, which was quite a setback for enforcement here, but I think the reasons for that include the cost of the High Court proceedings. These are very time-intensive proceedings to get a UWO, not necessarily just to get the evidence together to apply ex parte for the order, but really to then defend the challenge which inevitably comes after the UWO has been served, and to defend the applications to vary or discharge them. That's very costly. There is the duration of High Court proceedings, particularly given the existing court backlog that we already have here in the UK. High Court proceedings are long running, and there's also not just the need to prepare them, but to go the distance with them, to do with the UWO regime even before one even embarks on civil recovery proceedings. So there is that time element as well. Additionally, there's also the need, and this comes through in the code of practice, to consider whether there is another way of obtaining the information which might be easier. And so that might play a role in why we have had so few UWOs. There are political dynamics, I would suggest, that are at play. For instance, I think one issue, if a foreign PEP is one of the category of respondent, then going after that foreign PEP carries a whole number of political implications potentially, and it will depend on whether or the extent to which he or she is still very much in favour with their government, because there is otherwise political relationships and diplomatic relationships which could be affected, and that needs to be properly considered. Of the cases we have seen, because the respondents have had deep pockets, the cases have been very vigorously tested. Also, because this is new legislation, you can understand why there is enormous scope to challenge, test things, and appetite to do so. And so that has perhaps slowed the appetite for going after more and more UWO respondents. Finally, and this is more of a practical consideration, but given that the UWO is not in itself about civil recovery proceedings, what it is about is getting the information to ideally down the track launch civil recovery proceedings. There is then the need to, of course, consider any information which is provided. So to consider the response, but potentially go about an enormous amount of effort in considering it and potentially needing to apply for assistance from foreign jurisdictions to verify or discredit it. So in that sense, it is not the silver bullet when it comes to investigations that perhaps one ideally might have hoped it would be, because once the information is obtained, you still have the duty to look at it carefully, verify it, and if it involves any international evidence or anything like that, there is then the need to potentially go and get assistance from other states in looking at it. The cases that have been successful, the case of Hajieva, which is the first UWO that was obtained, that was an absolute success for the NCA, and I think it really set a precedent for what they would have thought would have been a number of successful UWOs to come. As I say, it hasn't necessarily gone that way, but this first case was an absolute milestone for them. I'll just step you through what happened there. So you had Mrs. Hajieva, who was the wife of a former bank chairman from Azerbaijan. So he was a PEP because of that, because he was the former chairman of the bank, which was state controlled. And as a result, she was a PEP, being his spouse. Mr. Hajiyev had been jailed for fraud as a result of embezzlement through that bank. And Mrs. Hajieva was identified by the National Crime Agency as having two high-value properties here in the UK. A home in West London worth some £11 million that was owned through a BVI company. There was also a second property as well, and she was identified as the beneficial owner of that company. Now, she was ultimately slapped with an unexplained wealth order, and they did that by looking at or providing evidence of what her husband's salary would have been when he was employed as chairman of that bank, and looking at the value of her home here in London, for instance, if we were looking at the London home. And so that was the way that the disproportionality between income and property was identified. She ultimately sought to discharge the UWO. That was not successful. But the arguments she ran, and there were a number of them, but she ran a point that her husband was not properly a PEP because of the amount of interest that the state of Azerbaijan had in that particular bank. So she ran a technical point about that. She ran a point about how the NCA's reliance on evidence that her husband had been convicted of corruption and embezzlement could not have been safely relied upon by the court. But ultimately that wasn't successful. She ran a point about how the UWO regime ultimately would lead to self-incrimination, and that infringed human rights. So obvious human rights points, which I think if Jamaica were to introduce legislation of this kind, will no doubt come, because they've come in the UK, they've been taken in Australia as well. So points about self-incrimination, points about the proportionality of a reverse onus, they were all points taken in Mrs. Hajiyeva's case. But ultimately, those points were not successful on appeal, and the order was upheld. Now, that was the case of Hajiyev. The first UWOs in that case were obtained within months of this framework entering the statute book. So this was from 2018. There was then the appeal in December of 2020, and we still haven't had the successful resolution of any civil recovery proceedings just yet. So that is still working its way through the courts, but a very successful first outcome there. Now let's look at the second case where UWOs were obtained. Again, also successful. This might be of perhaps more interest to those of you listening, because rather than so-called glamorous foreign PEPs with estates here in the UK and grand corruption being part of the background, this was about targeting a person suspected of involvement in more conventional serious criminality. So here, UWOs were obtained against 8 properties owned by a Mr. Hussein. Now, he was a 39-year-old professional. He had a rather vast property empire, but nothing in the form of any prior convictions, and just one caution for a very minor matter in 2009. He was made a respondent to UWOs targeting his specific property. And the reason for that is not because he was a foreign PEP or connected to one, it was because he was suspected of involvement in serious crime. And the crimes there that he was suspected of having or some role in were to do with drug trafficking, firearms, money laundering. The evidence was, or at least the suspicion was, that he was an enabler and holding and using wealth on behalf of organised criminals. The UWOs were obtained. He then responded as was required of him, and he did so in a way that it filled 147 folders, so an enormous amount of material for the authorities to go through. But they ultimately did, and then they were then able to launch civil recovery proceedings because the information was not found to ground any reasonable explanation of these assets. Now, that case has recently settled with an out-of-court settlement of the civil recovery proceedings. And so another good outcome there for the NCA. And in a case, another precedent being set, because in a case where the respondent is a suspect of serious criminality rather than a foreign PEP. Where things, though, did go a bit wrong, and I think this is really what has been rather sobering when it comes to the enforcement authorities looking at UWOs, is the case of Baker. And that is a 2020 case where at first instance, at least in 2019, UWOs were obtained, and they were obtained in relation to a respondent called Mr. Baker, who was a professional trustee and a solicitor on the roll here in the UK. He was the president of a number of Panamanian arrangements, which are akin to trusts. And the UWOs were served on him because the evidence there, or the suspicion there, was that he was holding property which had been acquired by Rakat Aliyev, who was the former Deputy Foreign Affairs Minister of Kazakhstan, who had been convicted of corruption and money laundering in connection with his office in 2015, or convicted earlier, but ultimately died in prison in 2015. And it was thought by the NCA that the properties that he had here in the UK, which were now sitting in this Panamanian arrangement headed by Mr. Baker, were all the fruits of his money laundering and his corruption. So practically speaking, the UWOs were then obtained, and they were served on Mr. Baker, and he was asked to explain, well, how were these properties funded? And he was asked to do that by way of a video statement and request to deliver up certain documents. Now, that was all well and good, but after those UWOs were served, what then happened was that Mr. Aliyev's ex-wife, I'll just go over the page here, Ms. Dariga Nazarbayeva, who was, or is, I should say, a very prominent person in Kazakhstan. She is the eldest daughter of the ruling figure there. She's also a very successful businesswoman. She provided a large amount of information to the NCA, laying beneficial ownership to at least two of the properties which were the subject of the UWO. And she and her adult son provided this information to the NCA. The NCA looked at that information but refused to withdraw the UWOs and pushed on in its case that these properties belonged at one point to Mr. Aliyev and did not belong to Ms. Nazarbayeva. And as a result, there were applications made by Mr. Baker to discharge the UWOs, and those applications were successful. And they were successful for a number of reasons. I suppose to summarize, because this is quite an interesting case, and it must be said, a setback for the NCA. But in particular, High Court Judge Mrs. Justice Lang was rather scathing in her assessment of the investigation that had taken place, not just leading up to the UWO application, but after, and considered that the NCA should have looked more carefully at who was said to have owned these properties, and should have looked more carefully at the explanations that had been provided by Ms. Nazarbayeva, and also did not think at all that the statutory criteria had been met by Mr. Baker, who was the respondent. And the reason for that is there wasn't said to be any grounds to suspect that he was in any way involved in serious crime or even connected to Mr. Aliyev, who was identified as being involved in serious crime. And so one of those fundamental requirements simply weren't met. What was interesting as well, because in this judgment, really there was quite a lot of discussion about the quality of the investigation. And Mrs. Justice Lang was of the view that the properties could not have had supported an irresistible inference that they could only have derived from crime, which those words, and they come from, of course, the case of Anwar, But those words aren't replicated in the Proceeds of Crime Act at all when it comes to UWOs. But that was what Mrs. Justice Lang discussed when referring to the need for a UWO in this particular case. At least in her mind, it appeared that a UWO really only ought to be available where there is, or at least a suggestion, I suppose, that there is an irresistible inference that the properties could only have derived from crime, a very high bar. The NCA after that, as I say, following that loss, it was ordered to pay the costs of the respondent, which were £1.5 million. And there was also, and I've put some of the quotes from the judgment here, and you can see really the court's concerns with that case, calling it a flawed investigation and reminding the NCA that they needed to carry out a fair-minded evaluation of the information. Really quite difficult for the NCA to recover from that. And since then, we haven't had any more orders. Another comment here, and this is just in case, no doubt, when UWOs are introduced in Jamaica, you will be having your own case law and perhaps drawing on the case of Baker as well to assist. But Mrs. Justice Lang also referred here to the use of complex offshore corporate structures as not necessarily being a ground for believing that they have been set up or are being used for wrongful purposes, opened the door to valid reasons for the use of offshore corporate structures, suggesting that that's not enough for suspicion. So very interesting obiter there. The NCA was refused leave to appeal on the back of Baker, and there have been no UWOs since. So looking finally at some lessons, and I've just gone through the 3 reported decisions. There is a 4th UWO case, but no judgment there. But that concerned, from the press releases about it at the time, UWOs which were obtained in relation to respondents involved in serious criminality rather than foreign PEPs. But in all of the cases that we have had, from Haji Ava, Hussein to Baker, what they do show is that the proceedings are rigorously contested, not just by the respondent, but at least in the case of Baker, by other interested or affected parties, including those who have a large amount of resources at their disposal. It also shows that the UWO is not a way to short circuit a proceeds of crime investigation, because there is an expectation, at least here, that they will only be used if other less intrusive ways of obtaining information are not available. And so that is one of the, not requirements in POCA, but one of the requirements under the Code of Practice. What we're seeing, at least in the last case of Baker, is that judges are not prepared to just rubber stamp UWO applications on appeal. They are scrutinising the provisions very carefully indeed, no doubt because of its invasive nature. And at least in the last case in Baker, reading into the legislation, which I think is rather interesting, the idea that a UWO can only be obtained if there is an irresistible inference about that property. As a general point, it shows that the UWO proceedings we have had can be very resource intensive, not just preparing the application at first instance, but then needing to consider the response or even pre-response information which might be provided by other affected parties, like it was in the case of Baker. Enormous amount of information was provided which needed to be properly looked at. And that was not even the information which was part of the response. And so that can be very resource and time intensive. The case of Baker also shows that the authorities are going to be held to a very high standard. I think some of the comments by the court in Baker were really unsympathetic to the NCA, and it's difficult when it's considered that this is new legislation and the NCA were trying very hard to go after what it's suspected to be illicit property, and no doubt was sort of hampered because of opaque structures being in place. So it's very difficult to investigate in that situation. But the court in that case did say that all information must be considered, and did consider the investigation flawed. And so again, the courts are very robust when it comes to these provisions. And finally, and the point's been made already, but there are enormous cost implications in the event of discharge. And so something to consider here there in Jamaica, I should say, is whether you would be considering some cost capping provision like the kind which has just been introduced in the last month here. I'm just conscious of time because I want to leave time for questions. But the short point here is that this is still a new framework which we're finding our footing with. The new provisions that we've got in the last month do suggest that this framework is here to stay. But in terms of the proof being in the pudding, I don't think it can be said that they have been a roaring success, because we have had 2 successful outcomes. But in the third case, it showed that there were difficulties in I guess, obtaining the UWO where offshore opaque structures are in place, and where an enforcement authority might not necessarily have a vast amount of resources to look and crawl through all the information which is provided pre-response stage. To what extent as well the UWO provisions can really assist in cases where there is an international dimension, when the enforcement authority would still then need to look at mutual legal assistance requests in order to verify that information. I think that's something which needs to be factored in as well as things like, well, if you're going to go after politically exposed persons, how really does that interact with any immunity points down the line? A very interesting developing area, and I think these questions will inevitably be answered as more cases make their way through the system. Okay, a couple of slides on another route. Account freezing and forfeiture. No doubt this is something that you have already discussed as part of your law reform plans at the moment. But just to draw to your attention that in Part 5 of the Proceeds of Crime Act, we do have account freezing and forfeiture provisions, which are very different to the UWO regime, but were introduced at the same time. They are magistrates' court proceedings where money is frozen if there are reasonable grounds to suspect that it is recoverable property. It can then be forfeited if, to the civil standard, it is recoverable property. And these are the provisions. It's not the UWOs that are being used in a big way. It's the account freezing and forfeiture provisions, which are also introduced in 2017, which are making the greatest dent in practice. And in particular, and I'll just skip ahead, I've put the sections on the slide. But we've seen a number of orders made. They are made in the magistrates' court where the processes are far more straightforward. You don't have the major costs implications. And these are the orders which are being widely used and producing big yields. And I've got a few cases for you just to support that.
Anita, you've got a little bit of time, so you can go back to the rationale. You've still got. We started a little bit late, and I think it's been and you're not losing swathes of people as we come up to. So I think you've probably got another, 10, 15 minutes if you don't mind, and if nobody objects, we'll go through it. But I just love to sort of just touch on the rationale as well. I think that'd be very helpful.
Well, let's go back and look at that in a bit more detail. So basically, the account forfeiture provisions were introduced as part of the Criminal Finances Act alongside Unexplained Wealth Orders. But the main reason they were introduced was because it was identified that there was a lot of money which was sitting in bank accounts in the UK, sitting dormant, which the authorities just couldn't touch. So accounts had been frozen by the bank itself because there were concerns about the nature of the funds in the account, because there had been a suspicious activity report and there were concerns about money laundering and the like. But then after that, perhaps because it wasn't then worthwhile for some of the amounts involved for the authorities such as the NCA to pursue high court civil recovery proceedings, which, as we've explained, are very costly, time intensive. This money was just sitting in these bank accounts untouched for years. And the estimate at the time when the bill was going through Parliament was that there was between 30 to 50 million pounds sitting in these bank accounts. And that was really why provisions were introduced to allow for account freezing and forfeiture. Now, they are very similar to cash freezing and cash forfeiture provisions in terms of the test to be met for the money in the account to be frozen. But it's hard to believe, but before that, there was just no way of touching bank accounts. So looking then at the law, an account forfeiture order can only be made where the court is satisfied that the property is recoverable or is intended by any person for use in unlawful conduct. So property will be recoverable property if it is property obtained through unlawful conduct. And I suspect that is very similar to your proceeds of crime legislation in Jamaica when it comes to civil recovery. Looking at the results, I think because they have been used in such a big way, and it is meaning that millions of pounds are being forfeited using these provisions, but it also means it's being forfeited by magistrates, many of whom are not legally qualified. Quite often, depending on the court, it will be the resident district judge who will consider these matters because they do involve, in some cases, quite complex issues. But it's not uncommon for a lay bench to determine these proceedings. And potentially what can be forfeited is hundreds, if not millions of pounds in a bank account. So that is, from a practical point of view, I think nobody really expected that to happen. But that said, these provisions are very much here to stay. And from the perspective of law enforcement, they are a big winner. One of the first reported cases was from March of 2018. Here you had 3 bank accounts which were frozen. And this just gives you a sense of the type of cases which attract these orders. But you had the son of the former Moldovan Prime Minister who had 3 bank accounts here in London. He had no registered income at all, but it showed that he was receiving large amounts of money from offshore companies. he was being paid something like £98,000 over 3 days. He was driving a Bentley car, very extravagant. So you can imagine it's a similar sort of situation to, I guess, the facts that would underlie an unexplained wealth order. The question in this case is, well, how can a 22-year-old student afford a Bentley? And so it's the same need for an explanation. But rather than going down the route of an unexplained wealth order, what the authorities did was freeze his bank accounts. And it ultimately had the same, I guess, outcome, because the freezing orders were obtained, about £500,000 was forfeited, and the cost of doing that was just £4,000. And so you're not running up an enormous bill, but you're still getting quite a valuable yield from that action, which is resolved within about half a day to a day in the magistrate's court. Another case, just to give some more context to these orders, you had here, and also the sorts of amounts that can be involved. You had account freezing orders on 10 bank accounts, which were made in 2018, 2019. That related to some £6.4 million. And the account holders, were two Azerbaijani individuals who had connections to members of the political elite in Azerbaijan. And the NCA's case was that the money sitting in those bank accounts had come to the UK as a result of money laundering schemes. Not necessarily the case against the individual account holders themselves, but more to do with the method of the money and how that money came to be in those bank accounts. And so that was the basis for the account freeze in the first place. Ultimately, I should go back a page, that matter settled, and there were £4 million that were forfeited. And so that was also a big win for the NCA for what were ultimately magistrates' court proceedings that were instituted. Now, very recently, this was just in October, just gone, you had here some £28 million, which was ultimately settled on an account forfeiture application. That related to a South African law firm and a Cypriot company having their bank accounts frozen, not necessarily because they were involved in any of the underlying suspected criminality, but because it was identified or suspected that the funds in their bank accounts were from unlawful conduct. Now, here it was not the NCA that was pursuing matters, but it was the Crown Prosecution Service. And this was, and is to date, the largest account forfeiture matter which has ever been settled. And that was settled for £28 million. Again, for what were ultimately magistrates' court proceedings. Some of the latest figures. So as I say, we've had 9 UWOs from 4 cases. But when it comes to account forfeiture, a year ending 2019, there were 740 bank accounts frozen, 94.9 million pounds then frozen or forfeited ultimately. You then the following year see an increase on that, 812 accounts frozen in the magistrates' court, and ultimately over £200 million forfeited. And the benefits of account forfeiture, as opposed to UWOs, of course, are that they are magistrates rather than high court proceedings. They are fast, remembering that the UWO framework is not of itself civil recovery. It is the step before, and it is an order made at an early stage, whereas account freezing and account forfeiture is all about recovery rather than investigation. Minor costs exposure. There's no reverse burden, at least in the provisions for account forfeiture that we have in the UK. So there's not necessarily the need to consider enormous amounts of information pre-forfeiture or pre-recovery like there is in the UWO framework. And this works both ways, no doubt, for the respondent as well. But there is far less publicity surrounding the use of account forfeiture orders. Although they are open court proceedings, they don't attract the same level of attention, and they're not as drawn out as high court proceedings as well. Another route, and this might well be similar. Oh, sorry, I'll step through this in just the last few minutes remaining. But another route that we have here on our POCA statute books is Part 6, which is taxation driven, but a regime for unexplained wealth to be taxed. So again, it has a similar rationale to the UWO framework, but it's directed at targeting illicit wealth through taxation. But where the NCA suspects that income is from criminal conduct, it can serve a notice enabling the NCA to perform revenue functions and attempt to claw back some of that money through raising a tax demand. And so in that sense, sorry, I don't know what's happened with my slides here, but in that sense, the NCA is then able to tackle illicit wealth, but do it another way rather than going down the UWO route. Here, and this just completes that point, but the NCA can be involved in a wide range of tax investigations if they ultimately suspect that there is some illicit wealth there. They can look at income tax, capital gains tax, corporations tax, and so on, and their tax recovery can go back a period of 20 years. So that the Part 6 powers are very valuable indeed. Now I think, Alan, I'm conscious it's 2 minutes past 9. I do want to open up the...
Don't worry, you've got... you go to the end. We're fine with time. We started a little bit late. We're not losing too many people, and we haven't had any questions in the chat yet, so I'm not sure. Although I've got a question, but we're fine, Anita. The information is fantastic. Don't forget, this is very early doors for us in some ways, so this is very interesting.
Okay. Oh, good. So I think then just some concluding thoughts. If we go back to the original question about whether the UWO is a game changer or is it a paper tiger, I mean, I think it is a game changer because it has an enormous deterrent effect. Certainly when they were introduced, and even now, there is a lot of discussion about them. There's a lot of discussion about how they can be used, whether they still will be used. The UK is one of the few jurisdictions with them. And so that on paper looks great, but the difficulty has been how some of these cases have gone in court, particularly the case of Baker, particularly the problem with costs, raising the question about, given some of the criticisms of the NCA in the case of Baker, whether enforcement authorities are properly resourced to take on these big UWO cases. Mindful that the respondents have deep pockets, mindful that they are long-running, vigorously contested high court proceedings, mindful that the purpose of the UWO is to obtain, quite a lot of information of a financial nature. Really, there is the need for the enforcement authorities to be properly resourced to investigate and look at that information if UWOs are going to be effective. As I've just gone through, the account freezing powers, they are the ones that we are seeing used far more, and they have yielded so far forfeiture of over £200 million. Inevitably, whether it's account forfeiture, whether it's UWOs, more powers to do with tackling unexplained wealth will mean not just looking at those respondents who are the account holders or the people who hold that property, but also I think attention turned to other professionals and financial institutions who have facilitated in any transactions or purchases in any way. And we're starting to see a bit of that. I think the reforms we've had in the last few weeks are very interesting. And I expect, you know, given we've had that setback in Baker, I expect that these new cost reforms will actually mean that the NCA and others will begin to rebuild their confidence so that UWOs will be pursued. But whether they are, I suppose, really the only way of doing things, I think that is very much not the case, but rather they are a complementary measure against within a package of investigative orders, which can be deployed in the right case, but only if the authorities are properly resourced. Okay, I hope all of that is helpful. I will stop the share now. And if there are any questions, I will be very happy to share my thoughts.
All right, Anita, thank you very, very much. That was incredibly comprehensive and informative. Thank you. And we've got at least one question. Just before I do, I just want to acknowledge a couple of people who've been good enough to join us. We've got just like to acknowledge Professor Shazida Ali from the law school at University of the West Indies, and also Professor Tony Clayton, also from UE. So thank you both for joining us. We've also got Lloyd Distant, who's president of the Jamaica Chamber of Commerce. So thank you for joining us, Mr. Distant. And also we have a newly minted judge, Maxine Jackson, who was with the Office of the DPP, but has recently been appointed to the Supreme Court. So thank you, Maxine. It's great to see you join us. Carleen Barnaby has a question. So Carleen, if you'd like to unmute yourself and ask Anita your question.
A very comprehensive presentation, Anita. Just one question I have. You mentioned in your slide that it's not a criminal offense to respond to the UWO. Could you elaborate on what available options are there for the NCA to actually get the information or to deal with the non-response?
That's a great question. Contempt of court proceedings is the short answer. It is, yeah, it's not a criminal offence not to respond, but if there is breach of the order by ignoring it, there would be contempt of court proceedings.
All right, thanks. Has anybody else got any questions? I appreciate we're a little over time, but Anita was good enough to say at the start she didn't mind running over a bit. So yeah, Rob MacArthur. Just for some people I know and some people I don't. Rob MacArthur is from Her Majesty's Treasury in the UK, and not only can you see Rob now, but hopefully you'll see a bit more of him later in the year, because we're hoping he's going to be helping us with some of this. So hello, Rob, and what's your question?
Thanks very much. Thank you for the introduction. And just very briefly, as Alan mentioned, I work for HM Treasury in the UK, part of the Technical Assistance Unit. And in very brief summary, our team works with partner countries to help implement the Financial Action Task Force standards. My background is law enforcement, and by a complete coincidence, I was the financial investigator on the Moldovan case, which Anita mentioned, and we also have on the call the co-lead for my team, Nadeem Ahmed, who is the lead barrister on the case. So thank you very much for the invite, Alan, and thank you very much for a really interesting presentation. And HM Treasury Technical Assistance Unit stand ready to come out and help the Jamaican authorities if there is any consideration for bringing in some non-conviction based asset recovery tools. So I will apologise in advance for a hypothetical question, Anita. Thanks for your detailed presentation. And if the account freezing orders or listed asset provisions were widened to include action against real estate, as mentioned in your case examples, do you think that law enforcement would still consider using unexplained wealth orders? Thanks.
That's a great question, and I would be interested to know if that's actually being considered. I would.
Anita, just before you do that, can you just explain? Some people might not know what the listed assets provision is, so can you do that in 30 seconds or something, and then sort of answer Rob's question? Would that help?
Yes, sure. So it's very similar in structure to the account freezing and forfeiture provisions, or cash freezing and forfeiture. But basically, there are identified assets which are seen as, I guess, particularly vulnerable to moving proceeds of crime, such as jewelry, gold, precious metals, artwork, watches, things like that. Listed assets, if they are suspected of being the proceeds of crime or obtained through unlawful conduct, they can be frozen and then also forfeited in the magistrate's court. The second, I guess, hypothetical, which is interesting, which I'll think about there. I would have thought that if those provisions are widened to include real estate, then UWOs will really become less attractive. But I just wonder that if, given some of the real estate that has been involved in the UWOs to date, which are tens of millions of pounds in value, I mean, magistrates' courts were not set up to deal with things like that. But then equally, one would say, some would say that about bank accounts with tens of millions of pounds in them. So I don't know. It'd be a matter for Parliament. But I would have thought if they were widened, UWOs will fade into the background.
Thanks very much. It's interesting. If nobody else, I've just got a question, really, Anita, while waiting for other people. But Jamaica's talking about introducing its own UWOs. So we've talked about a lot of things that have gone wrong and right with UWOs. But if we're introducing our own legislation, what do you see as the key pitfalls that we should avoid when introducing our own legislation? Kind of what did the UK do that probably wasn't right, or other jurisdictions have done that maybe was right and that we could introduce? So, because the whole point of this is we don't want to make the mistakes other people have made, and we want to sort of shortcut things.
Yeah, that's a really good question. I think that the legislation that we've got in the UK does contain very good safeguards, in that it has the express rights to review and appeal, and it has what can and can't be done with the information. I think that's good. I think that there are things that still need to be clarified, in that, for instance, given that a lot of property can be hidden away in a trust, and now given that trustees and directors of companies, for instance, can now very recently be made respondents to a UWO, it's not entirely clear to me, it might be clear to other people, but how then the income requirement works in that situation. And that was a point that, say, Mrs. Justice Lang picked up in Baker. Like when you're looking at, say, a professional person who might be a lawyer, potentially being a respondent to a UWO, which for obvious reasons you would want, because a lot of these properties are squirreled away in opaque structures. What does that then mean for your criteria? Like, how is that then set up? I think those are some questions. I think if one was looking at introducing a UWO framework, then there needs to be the expectation that those proceedings are going to be open. They're going to require all the evidence to be properly served. There's going to need to be the right to review, the right to, and also if information is provided at any point, whether it's by the respondent in answer to a UWO or whether it's by an affected party before the response is due, there needs to be a mechanism in place for dealing with that volume of information, and dealing with it properly. I suppose that came a little bit undone in the case of Baker, it would seem. Right.
Okay, thank you. Yeah, I think that's going to be very. Yeah, these are the things that we're going to have to start thinking. You've got a question. Caroline Hay has got a question. Caroline, do you want to do your question, or shall I read it for you?
Well, I wasn't sure. I'll just go ahead and ask it.
Please.
Thank you very much, Anita, for a very thorough presentation. I look forward to actually receiving it so that I can go at the cases myself and have a read. But I was just thinking about the comparison you made, or the parallel jurisdiction in the criminal law world of the illicit enrichment charge, and how it looks similar. But if the unexplained wealth order is basically civil and uses civil recovery proceedings to advance it, do you see an issue with mutual legal assistance, where many countries rely on dual criminality for the base qualification to approve a request, or at the least require that the underlying criminal allegation that generates the asset is a crime, even if it's called something else in the requested state? Are there any issues there? Because I'm listening to the cases that seem to have had an international assistance aspect in the UK, but in the Caribbean territories and in some of the other Eastern Caribbean states, South American countries, that are very strict on the request fitting within scope. Do you see any issues there with assisting that in that way, given how mutual assistance is structured? Sorry for the long question, but that's what's
No, thank you so much, Caroline. I think that is an excellent question. I do see issues there. I mean, I can't speak from any experience to do with the Caribbean, but certainly given civil recovery in some jurisdictions, in fact, in a lot of jurisdictions, isn't at a mature stage. There are very few countries with UWO provisions. I think that there are issues potentially with, if, for instance, these international enforcement provisions were used in order to try and get assistance from another jurisdiction. I think that potentially we would be met with a roadblock depending on the jurisdiction, because they wouldn't be familiar necessarily with either UWOs or yet have the legal infrastructure in place in that jurisdiction for civil recovery to the extent that it exists in the UK. So for that reason, yes. So although on paper UWOs, at least in POCA, do say that they can target property overseas, I think it would be difficult, which is why perhaps in the few cases we do see, it is all about domestic property.
Thank you.
We've got a question from Roderick Williams, which is, I think, is more on a technical basis, which says, you say the authorities have 60 days to make a decision after receiving a response. Are there any provisions to extend the time to go through the response that may be provided by the respondent?
Yes, that is a great question. Let me look that up, because I don't know the answer off the top of my head. So I'll look that up now, and then if there's another question.
Okay, well, we've got somebody, Nad, please excuse me if, but it says, in terms of lessons learned from UK experience. Oh, there's Nad there. Okay, I'll read it over, Nad, if that's okay. Oh, I didn't realise that. Right. Okay, so this is the other arm to Rob MacArthur. So this is Nadim Ahmed, who's also from HM Treasury, who's involved.
Thank you so much for the introduction. Anita, thank you for an excellent presentation. I'm also joining from London, like you, after an afternoon of cricket. Forgive my cricket weight. So one of the things I put into the chat bar is that in terms of lessons from the UK, so just to say I was the NCA's barrister for 12 years, and I dealt with the first 9 pilot account freezing order cases, including the one that you mentioned about Mr. Filat, Ms. Chalkat, sorry, and Mr. Riaz. These were all, high value cases. And I think one of the lessons worth considering may be thinking about sequencing the introduction of any new provisions. So if I were doing it again, I think I'd introduce AFOs first, UWOs second, see how you go with AFOs. And I say that because I think that with account freezing orders, there is still scope to go after or include real property where, for example, an investigation is triggered by an account freezing order. There may be a respondent who says, look, the reason there are tens of millions of pounds in my account are because this money is equity in so-and-so high-value property that I have in central London. It's entirely explicable. Later on, they may capitulate with such or struggle to sustain such an argument. And you could be in territory where you're talking about a settlement which requires the sale of property. What I'm saying is that it's not beyond the realms of possibility. So that may be something to think about. The other point I wanted to make, Anita, was I agree entirely with what you said about was the magistrates' court intended to deal with complex arguments about offshore trusts and high value transactions. No one has actually taken that point. No one has sought to judicially review the legislation. And I'd say two things. First, the legislation makes clear that account freezing orders, that there is a minimum amount. What it doesn't do is set out an upper limit. So if I was acting for law enforcement today, I would argue that Parliament never enacted an upper limit, and therefore the intention must be construed as drafted. In other words, that there is no upper limit and that the Magistrates' Court is the entire appropriate jurisdiction to be dealing with these high value cases. I have to say, when I acted for the NCA, all of the pilot cases were initiated in Westminster Magistrates' Court, where the district judges were all legally qualified, so there was no lay bench, and we would seek to avoid, I would suggest, putting a high value case in front of a lay bench. Thanks very much. That's all I wanted to say.
Thank you so much.
No, that's great, Nadia. And that's that kind of experience and knowledge that yourself, Anita, and Rob, and people like this bring. So it helps us to understand a lot more. And I think one of the things that will come out today, I'm sure, is just how much is involved in this. But Anita, we've got a question from Susan Watson-Bonner, who's at the Bank of Jamaica, though previously with the FID. And whilst after first praising you for a great presentation, she says, does legal professional privilege apply to attorney at law acting in the purchase and sale of real property in the UK? If yes, how is the UK treated with challenge in receiving information from attorneys in support of, it says UBO, but I presume it means UWO applications?
Yes, so you
can see it in the chat if you
yes, I'll just have a
quick look, because it's
is it further up?
It's the last question. It's right at the very bottom of the chat.
I guess I'll just.
It's from Susan Watson. It's at 3:22.
Oh yes, I can see.
All right.
Does well, I think the answer is no, because that's transactional. So in terms of advice given in relation to the transaction would be privileged, but the details of the transaction itself is not going to be privileged, because the fact that X property was sold on X date for X sum, that's not going to be privileged. But certainly I would have thought the advice which is given by the solicitor to the client, if it's on the purchase and sale of the property, would be. How is UK treated with challenge in receiving? Yeah, I hope that assists. I don't know if I can answer the rest of that.
Yeah, I think unfortunately, Susan isn't able to sort of speak and sort of address it more. But I think it's this whole sort of thing about this request for information. Does it sort of compromise the attorney's position here? Because in respect to UWOs, given the nature of them.
No, yes. I mean, I certainly, the details of the transaction itself wouldn't be privileged, but any advice that was given on it would be. And so you'd have to be, like with anything, like when drafting a SAR, a suspicious activity report, you have to be very careful about what information goes in, but transactional information by and of itself is not privileged.
Okay. Okay, we've got Rowan from the MNS who introduced you, opened up the seminar, who's going to take final responsibility for all of this. So, Rowan, I think unless we've got any other questions, I think we'll make this one the last one of the afternoon because it's nearly 3:30. And are you defending or prosecuting tomorrow, Anita?
I'm defending tomorrow.
All right, we'll keep her here till midnight. Let's make her tired. Let's make her tired.
I'll try not to keep up your time, Anita, but really thank you so much. I think you've kind of reinforced some of the information which we've found in our research. One of the things that didn't come out very clearly though, and I'm not quite sure why, in terms of, I know that the UK legislation speaks to who can be served at UWO. Most of the information that we have in our research is based on foreign PEPs only. I wonder the second grade of persons who may be involved in serious offences. Not a lot of information is available on those. And I'm wondering, to your knowledge, are you aware of any UK nationals who might be subject to UWOs? And I try to juxtapose this against what we would be doing, because most of our UWOs will be against Jamaican nationals.
Yes, that's a great question. So the case of Hussein, which I referred to, that was on the basis of criminal suspect category and not foreign PEP. And certainly in Australia, those jurisdictions which have UWOs, they're all directed at criminal suspects and not at all at PEPs. So there is no difference really. If anything, one would have thought the case might be a little bit easier, because if they are a criminal suspect, you would have all that information already in terms of ability to support the application. Whereas a foreign PEP, there are other political issues there at play, which you wouldn't have when dealing with criminal suspects. But certainly the case of Hussein might assist you, Rowan, when looking at that, which is a reported judgment.
Okay, certainly. Thank you so much. One of the things that worries me, and I'm sorry to be saying this to my colleagues from FID as well as the MOC and the JCF on the seminar, is that I know that we're not particularly keen on doing very detailed investigations. And I know that one of the drawbacks, or one of the safeguards that was highlighted in one of the judgments, in several judgments, was that the UWO is not, it should be the last resort. It should be, if everything else would have failed, that we then, the UWO will kick in. One of the reasons why the UWO was not supported by our chambers to move forward was because there wasn't sufficient justification provided by the ministry to show that what we were actually proposing was demonstrably justified to ensure that the constitutional rights of individuals were not breached. So that is something that I guess in looking at some of those cases that you've highlighted in your presentation, we should be able to get some kind of a direction in terms of not to make the mistakes that, as Alan and Nadra pointed out, that the UK would have made. So we can have a kind of a seamless, well, maybe not seamless, but an easier path in implementing our UWO.
Alan, I just wanted to get back, I think it was Roderick's question about the 60 days.
Yes.
362D of our POCA, doesn't have any provision to extend time. So the decision must be made within 60 days.
Okay, so by the look of it, Roderick, that's your 60 days, and you're kind of stuck with it. So you're gonna have to get your finger out, I think, is the it's unflexible. We've got one last question, and we will make this the last question. Is that all right, Anita?
Yes, yeah, absolutely.
You sure? I don't want to keep you up too late. It's just from Ophelia Callan. Thank you, Ophelia. It says, Anita, in view of concerns and challenges, has there been any consideration for amendment of any other legislation to aid UOs or UO applications? I think obviously what we're talking about.
Yeah, so we've had those recent amendments last month, which are quite focused, to do with costs and opening it up to, say, company directors and so on. I do know that there is because there's a report which has been commissioned by the government, which has looked at more amendment of the UWO framework, particularly to make it easier to target trusts and so on, and other things. So I know that there is a lot of discussion about that, but we've only just had those recent reforms. So I think it'll be a while yet before we see more changes to the UWO framework. And I guess, to be fair, it's not just Parliament which plays a role in this, but these matters will be the subject of case law as well. So I think the two together will hopefully lead to a bit more clarification.
Excellent. Okay, and I think the thing that's come out for me today as well is this whole idea of maybe that we need to maybe look at AFOs, and maybe Nadim's idea that and from Rob as well, that we maybe look at folding property into it, and who knows, or maybe we go down the UO route as Rowan's saying, but we learn the lessons of Hussein. But I think there's certainly given us enough to think about this afternoon, Anita. So thank you on behalf of everybody here, Anita, and especially on behalf of the FID, or the Ministry of National Security and the FID. Thank you very, very much for your time. It's been an excellent presentation. Rowan, you've come back on. I suppose I should ask you to say a few words of thanks. Actually, my apologies. I got ahead of myself.
No, not at all, Alan. You're doing perfectly well. Thank you. Please go ahead.
All right. Well, on behalf of us all, I just like to say thank you very much. I think it's given us a great deal to think about. I strongly suspect this is not the last we will see of you, Anita, but I think we now. I think looking on Rowan's face and that, you can see there's a man now who's got a lot to think about. But I think it's been very good, because it's highlighted things that went right, things that went wrong, and this is what we want to learn. We don't want to make the mistakes of others or go down the cul-de-sac. So I think it's been an excellent presentation. It's been very useful, and we thank you for your time and trouble. And as I say, it's nice to meet you electronically. Hopefully we'll see you physically at some stage.
So thank you very much for the invitation.
All right.
And for your contribution.
Thank you. So thank you very much, everybody. It's been a Sunday afternoon, and it's gone 3:30 when we were going to finish at 3, and we haven't lost that many people who were with us from the start. So thank you for staying with us. And for me, that shows the level of interest that people may have said they were going away, not had Sunday lunch yet or something like that, but people have stayed and joined in. So thank you, everybody, for your contribution, your interest. And we'll be doing a lot more of this with the MNS and the FID, and more of these sort of presentations and workshops and discussions. So keep an eye out. But once more, Anita, thank you very, very much. And thank you, everybody, and enjoy the rest of your Sunday.
Thank you.